In a constitutional democracy like India, which has faced many challenges, probably terrorism is one of the serious most challenge that one can identify, which is kind of an ugly phenomena which bedivides our constitutional democracy. And we are looking at ways and means to tackle this challenge. So, what are the laws which were framed to counter terrorism in this country? That is the subject matter of today's deliberation. So legal responses would be one, policies are other, but primarily I'll be focusing on legal responses. Remember the different images of terrorism which comes to our mind. Bloodbath, bodies drenched with blood. And so with these images in mind, one targets such responses. In a constitutional democracy, it has to be response, has to be within framework of rule of law, constitutional framework. So let's try to examine how anti-terror laws work in this country. But before I start analyzing anti-terror laws, just think of the contemporary times. We are actually living in extraordinary times, and the pandemic has produced effects both on policy and behavior, and is shaping our conduct, ourselves socially and professionally. Even during these times, certain extraordinary special acts, such as Disaster Management Act or surveillance tools like Arod Setu, have been invoked. Now, the question which we may ask, will they remain temporary or will they get entrenched as permanent measures? So while we live pandemic, while we engage with pandemic, and we're trying to survive, and these are the moments when we are willing to trade off everything else for our life. So it's historic time which we are living in, and this would really help us to understand the whole notion of extraordinariness. What kind of life we live when we are living in extraordinary times. So when we're thinking of extraordinary laws, special laws, we actually are thinking of such times, and such laws come in order to engage with certain virulent form, vicious form of criminality, what we consider to be terrorism. So the question which we're going to ask, how has law responded to terrorist activities in India? And there's a whole set of questions which I want to bring before you. And at the end, I want to leave with certain more questions which you can think, we can respond. So what are the specific laws passed by Indian Parliament to meet the challenge of terrorism in India? How many anti-terror laws have been passed by Parliament in recent history? And what are different laws passed by state legislatures to deal with terrorism and organized crime? Because the moment we're thinking of anti-terror law, our immediate attention goes to the Parliament, the body which framed the law, and Indian Parliament has framed certain laws in the last 4-5 decades. But what we miss most of the time, that along with the national law, you do have responses coming from the various states. And those laws also are part of this deliberation. The next set of questions that we ask is, what are the distinctive attributes of anti-terror laws? Means we are talking about anti-terror laws, but what are the attributes? And how are anti-terror laws different from ordinary criminal laws? What are different ways in which extraordinary anti-terror laws and ordinary laws have interlocked? So normally what we have is a whole set of special laws, extraordinary laws, the many extraordinary laws, but our focus is on anti-terror laws. And so the first question which you're asking is, how are these laws different from ordinary criminal laws? And though they are different, but are they compartmentalized, or do they interlock with each other? Means, remember, ordinary laws continue, and then there's these special laws which comes in. And see, this is what Parliament does. But then there's judiciary. So we need to ask the question, what has been the response of judiciary to the anti-terror laws? Means a tentative answer which we can right now think is all such special laws have been accepted by judiciary. They have not declared any anti-terror laws null and void, ultra virus. So they have accepted. But they also have given directions to make it sometimes more humane or follow the principles of rule of law. So they have sometimes suggested certain guidelines. We have a body, a statutory body, whose role is to deal with anti-terror, not only anti-terror laws, which actually is there to, deal with issues of violation of human rights. NHRC, National Human Rights Commission. If given the time, we can also look at role of NHRC, especially in mid-90s, the initiative which NHRC took when TADA was applied and National Human Rights Commission took this opportunity to review the whole phenomenon of anti-terror law. So as I said earlier, it's not only at the national level, there are regional variations also in terms of legal responses to acts of extremism, militancy, terrorism. So this is a whole set of questions which we have in mind when we deal with anti-terror laws. But before we come to the laws, let's look at facts, figures, and pattern. I mean, you have South Asia Terrorism Portal, which has real data. You can visit the site and you can find details of number of incidents which have happened where so many terrorists have been killed, or so many civilians have been killed, or so many security forces have been killed. Broadly speaking, what we see a trend, at least the last 2 decades data which I have seen, there are figures going back even before that. So from 2000 to 2011, the figures of killings in terrorism-related incidents, including deaths of civilians, security forces, terrorists, and extremists, are in 4 digits. So what I'm saying is that if you look at numbers, and I've got this number over here, so in 2000, there were around 1,910 incidents, 1,260 civilians were killed, and 573 security forces were killed. And 2,260 insurgents or terrorists or extremists were killed. So total was 4,121. So now there's a whole series of numbers which you can go on the website and check. What is the pattern? Pattern is from 2000 to 2011, the figures of killings in terrorist-related incidents was all running into 4 digits. Say, for example, in 2000, it was 4,121. In 2001, it was 5,504. And if we go to 2011, it was 1,059. So there is a decrease in number, no doubt, from 4,000. Well, in 2001, the highest was 5,504, which included civilians and security forces, and of course insurgents and terrorists and militants who were killed. So that's the period for a decade or so. But then 2012 onwards, we see a steady decline. And so in 2012, it was sort of 591. 2012, the numbers were 837. My apologies, it was 837. And in 2020, it was 591. So you get 3 digit, except for in 1 year, it went again to 4 digit. But from 2012 onwards, what you'll find is from 837, we have reached a figure of 591. In 3 months of January, or rather 4 months in January up till now, there have been 155 killings. So total killings from 2000 to 2021 April is around 45,586. So absolutely no doubt that India faces a very serious challenge of terrorist-related violence and crime. These are huge numbers, right? 45,586 in sort of 21 years. So we have to bear this in mind when we're looking for, trying to understand why anti-terror law. So the background is terrorist activities in parts of country, Jammu Kashmir, certain areas of northeast, central India, where there are militants, there are insurgents who are there, and civilians are getting killed, insurgents are getting killed, militants and terrorists are getting killed, and security forces are also suffering. There were other reasons also for bringing special laws, like United Nations passed resolution 1363, and thereafter many such resolutions after 9/11 bombings which took place in USA. So after 9/11 disaster, United Nations took note of this very seriously, and all countries, it became mandatory to have legal framework, policy framework to deal with terrorism. So there were international reasons as well as global reasons as well as domestic reasons for this. Let's turn to one of the laws, anti-terror law, the National Anti-Terror Law, Unlawful Activities Prevention Act cases, and see the numbers over there. In the sense, how many people were put under arrest, how many accused were put on trial after getting the requisite sanction of central government. So for past few days, I looked at Ministry of Home Affairs site, and there you have this monthly report about achievements of Ministry of Home Affairs. And in that monthly report, except for 2 months, you have for the past 3 years, every month you have numbers given, the sanction approved, the sanction given by central government to put those accused on trial, to prosecute them. So after POTA was revealed, POTA was repealed in 2014. So once it was repealed, then the UAPA cases, the number of UAPA cases increased. UAPA is Unlawful Activities Prevention Act. The cases increased. And this is the data, I'm sharing it with you, from the NCRB, right? The government agency which collects and collates data. So 2014 POTA was repeated, and we'll go back to that story later. But right now we're talking about facts and the figures over here. In 2014, according to NCRB data, there were 976 cases of UAPA. On 976% UAPA was applied. In 2015, it was 897. 2016, it was 922. 2017, it's 901. And 2018, it jumped again, and the numbers went up, 1182. And maximum number of cases were coming from states like Manipur, Jammu Kashmir, and Assam. Say, for example, from Manipur in 2014, there were 630 cases, and 2015, 544 cases, 2017, 382 cases, and 2018, 289 cases. Likewise, you have figure for Jammu Kashmir and Jharkhand. So cumulatively, what we get is till 2018, 39,920 cases were pending for investigation from previous year. And in 2018, another 1,182 cases were added. So total number of cases filed and awaiting trial till 2018 were 5,107. So you can have broad figure of 5,107 cases filed, and they were awaiting trial. Now from 2018 to 2021, of course, many more cases have come up. So, we can't speculate, but given the rate that, nearly every year, there were close to 1,000 cases, 976, 897, 922, somewhere around, so you can say average 900 cases. So in that sense, you can add another 1,800 cases to this law. Now, we all know that, laws and crimes do not work on this kind of mathematical calculation. but just average, if you can say, you can have plus and minus over there. So we are talking about around 7,000 cases. From 2018 to 2020, permission was given by the Home Ministry, Government of India, to prosecute the following number of people under UAPA. So it's part of procedure that police does investigation, fine, and they ask for sanction from the government. In 2018, 100, 2019, 312, 2020, 290 accused, central government, they gave this sanction for prosecution. What are the anti-terror laws? So we refer to, right now, we just talked about Unlawful Activities Prevention Act, and the numbers, 5,107 was the NCRB data. You can add few more to that because that's 2018 data. But this is something which is there. It's UAPA was there since 1967, and given time, we can go back to the history, but if only time permits. But prior to Unlawful Activities Prevention Act, there were two major acts. One, which you may have heard in different sources. The act was the Terrorist and Disruptive Activities Prevention Act, TADA, 1985, and then it continued till 1995. In 1995, TADA lapsed. Lapse means it was not renewed. And there's a very interesting part to this, that TADA had this review provision that if after so many years it will be brought before the parliament and parliament approves, then it will be renewed. So every 2 years review process happened. In 1995, it was agreed that this law is not serving any purpose, so it lapsed. So TADA was one of the first major anti-terror law which came in the wake of Punjab disturbances. We know that there was a whole movement for Khalistan. So in this context, TADA came in. And again, there's a whole story that, even though it came for one state and two union territories, but gradually it was extended to the rest of the country. So there's a pattern over there. The next law which we can talk about, and which after TADA, a law which came into existence after a gap of 5 years, was which came in the form of ordinance, and then it became a law. That is the Prevention of Terrorism Act, POTA, and the period was sort of 2001. It came in form of ordinance, but then it was passed in 2002 and continued till 2004. Now, POTA was repealed in 2004. Now, there's a distinction: lapse and repeal. Act of repeal is a kind of political act because Parliament actually passes a law repealing this and says that, from now onwards, POTA won't be there on the statute book. So it was repealed, and it was part of UPA, promise. UPA, which was led by Congress, the first UPA regime, it was part of the electoral promise that, well, POTA will be repealed. And the reasons were that it was misused, it was seen as sectarian, so there's a whole debate around that. Finally, we arrive at what is called as the Unlawful Activities Prevention Act, UAPA. Now, there's a whole history of UAPA. UAPA originally was enacted in 1967. So, and interestingly, during that time, on the one hand, Atal Bihari Vajpayee, a young parliamentarian, and on the other hand, Bhupesh Gupta from Communist Party of India. So Jan Singh and Communist Party of India both questioned, opposed the enactment of Unlawful Activities Prevention Act. So this was an act which banned organization. They were banned as unlawful. It happened after 1992. Certain organizations were banned, and in between there were other organizations were also banned. Now it is this act which was amended when POTA was repealed in 2004. And there lies the interesting part. So when POTA was repealed by UPA, certain provisions of POTA were included in Unlawful Activities Prevention Act. And in order to include those provisions, especially provisions related to interception, interception of communication, that was now added to Unlawful Activities Prevention Act. POTA was again amended in 2008, and this was, remember the context was Mumbai terror attack, and by amendment, certain provisions of POTA, which was repealed earlier, provisions related to bail and remand, were further added. So we'll come to that, why bail and remand were added, because there are stringent conditions for bail under TADA, it was same under POTA, and now Unlawful Acts Prevention Act also became the stringent provisions were added over here. And 2008, NIA was also enacted. So you keep on reading in newspaper, National Investigating Agency. So again, I'm not sure whether we will have time, to deal in detail. But National Investigative Agency is one investigating agency which does not need permission from the state to take up cases. Those cases, which fall under the schedule of NIA Act, anti-hijacking, okay, or any terror act. So the whole schedule in NIA Act. So in that sense, it is one central legislation where investigating agency have pan-Indian, jurisdiction. They can, if one central government notifies that this act of terror falls under the purview of the schedule, which is mentioned in the NIA Act, and it orders NIA to take up investigation, then NIA comes into existence, and all other agencies, would have to pass on the entire files and everything to NIA Act. Then, UAP, Unlawful Activities Prevention Act, was again amended, and many of you must be familiar what happened in 2019. That there was amendment made, and certain individuals now could be declared as terrorists. Okay, so there's now a whole procedure where individuals would be identified, and there's notification would take place, which is published in Gazette of India, and certain individuals can be declared as terrorists. Now, especially remember, after Mumbai blast, many were convicted by the courts, but Indian government could not, arrest them or extradite them. So they have been declared as terrorists. This is a worldwide phenomena that declaring individual as terrorists. So so many such members, many such terrorists have been declared under this, and so that's one of the last amendment which took place in this. Now I must pause over here, and we'll go back to the main theme. But the methodology, in terms of research, this is something which I've looked at. The whole phenomenon of laws and policies which deal with terrorism for the last 2 decades. But specifically, what I want to talk about is, see, the dominant discourse of anti-terror laws is part of jurisprudence of violence. That is, there's this violence taking place, there's this heinous act which is taking place, law is there to counter that, which is very much true. It does happen. Fine. After all, these are laws whose effect is supposed to be deterrent. But I would follow a violence of jurisprudence approach. Fine, because that's the dominant discourse. We have to engage with that. We have to understand that, but also look at the violence of jurisprudence approach, which means that I focus over here would not only be on laws of words. That is the nature of rules, principles, and procedures, which of course are very, very important, but also laws, deeds, and effects. Fine. So through this, what we are going to do, we are going to we are going to not accept a position that law is just an antithesis to abuse of power and violence. Many a times, such laws itself, they turn into abuse of power. And I'll give you evidence. I'll show you different discourses which actually refer to abuse of power. So for example, to call someone terrorist itself is a huge label. Remember, and this labeling of a person as a terrorist is virtually to condemn that person. And it's a very powerful label. Remember, the moment raids take place, someone is arrested, newspapers flash, somebody tells arrested. It has its effect upon larger section, family, neighborhood, community. Fine, and in case, and it does happen, it has happened in hundreds of cases, that the person has been found to be innocent, then that is very difficult to erase that label. So it's not just laws, words, it's the deeds also we have to look at. Also, scholars have shown that many a times it has led to creation of suspect communities. So in Khalistan movement, Punjab disturbances, certain community were identified, and later on other communities were identified, mostly minorities. But there's also a case that one should not criminalize laws. Fine, let the law take its own course, as people say. So we have to keep in mind both the sociological reality and the principles of the law. So law per se does not need not discriminate, but in practice, what has happened, we have to see. So we identified TADA, POTA, and UAPA. But interestingly, what we see is, and that's something which you have to keep in mind, there's a whole unending string of extraordinary laws in India. And so, you have a whole range of regulations during colonial times, 1838 Bengal regulation of 1818. Then you had Defense of India Act. And don't forget that, Gandhiji's own opposition to Rowlatt Act. But let's leave the colonial part. Independent India. Let's take up independent India, and then you have Republic is born, and you have Preventive Detention Act 1950 passed. Sardar Vallabhbhai Patel brought this act, and he actually said that he was bringing this act with a very heavy heart. Fine, but nevertheless, act was passed. If given time again, we can go back to this. Defense of India Act 1962, and then in 1961, remember Indo-Pak conflict, it was invoked. People, especially those are very very senior, remember, but more than remembering, you may have read, or colleagues may have read about MISA, Maintenance of Internal Security Act 1971, which was again amended under the emergency. It's a detention law, remember. It's not anti-terror law in that sense, it's a detention law. And figures as per Shah Commission, nearly 100,000 arrests took place under MISA arrests. So detention laws, it was used in a massive way. From 1989, we have National Security Act, and you'll find a lot of newspaper pieces on National Security Act, which was applied in different parts of the country for variety of reasons. We already identified laws specifically dealing with terrorism, TADA, POTA, and UAPA, but also keep in mind another law which protects the army to work inside disturbed areas, Armed Forces Special Power Act. Mostly Armed Forces Special Power Act have been invoked in border areas, Jammu Kashmir, Manipur, Nagaland, Meghalaya, Assam. Many scholars question this, that why is this law reserved for border areas, and why is this not invoked in parts of central India where Maoists are active, and that's something which probably again we have to think over. But I want to bring the distinction between the two, the preventive detention laws. Now, remember, preventive detention laws, they draw their force from Constitution itself, because Article 20 of the Constitution, which is part of fundamental rights section, actually makes provision for detention laws. And there are certain safeguards inbuilt with this detention law, constitutional safeguards, tribunal, and things like this. On the other hand, laws dealing with terrorism are different in the sense they are not detention laws. Now, many would say that they have been turned into detention laws, and those who take this position, they're absolutely right, because bulk of the arrests under anti-terror law, the accused remain in custody, in judicial custody, is under trial, but they were not put on trial for many years, and many were released after review and other things. But the difference is the anti-terror laws are substantive laws which set up exceptional provisions pertaining to investigation, trial, and punishment delivered through special courts. So there's a whole parallel system. You have special laws, special courts, special agencies. So a person of a certain rank would investigate, fine, and there are enhanced punishment under this, and trial would take place in, say, designated court or special court. So you have a whole parallel system working over there. So we need to, we are not lawyers. I'm sure, those who are all participating in faculty development program. My guess is there'll be very few lawyers, and many of you may be concerned that I'm going too technical. But see, we need to know, because you keep on hearing about Unlawful Activities Prevention Act in newspapers every day, arrest, denial of bail, something like this, or conviction. All these you keep on hearing. So this is an opportunity to know at least the finer details. The larger story again will go back to this, but the finer details I'll spend some time and then come back to this. Let me come back to larger processes over here.